So today, I'm extremely welcoming Ms. Olga Tispas to give us a very fascinating training session regarding the empathy, being aware of needs of others. Due to the condition, Ms. Olga may not speak very loudly, so please make your volume up if whereas needed. So Ms. Olga Tispas has been running her law office since February 2003, handling cases of all fields of law, civil, criminal, administrative, and personal data, etc. She is a legal counsel at the Association of Journalists, EDIPIT, as well as an external associate of the Aristotle University of Thessaloniki. She is a specialized in data protection officer and GDPR counsel, have undertaken projects throughout Greece and have conducted trainings at Bar Association and in other public authorities. Meanwhile, she is a data protection officer at the German School of Thessaloniki, and at the Disabled Club in Komotini, and has been a GDPR counsel in many compliance projects. So, meanwhile, in the meantime, Ms. Olga is a very renowned and very experienced mediator, both domestically and internationally. So, Ms. Olga, floor is yours.
Thank you very much, Mr. Chang. Sorry for my voice today is not very good looking because we have humidity outside. We are close to Christmas time, so sorry for not having the ability to speak very, very, very loud and very clearly. But I really wanted to be here with you today, not to miss a chance to be again with you. And of course, I want to share all the experience and all the knowledge I have with you. So again, thank you, Mr. Chang, thank you, GD, and thank you, SCLA, for this opportunity to be here with you. Don't worry, you're not going to listen to me for a long time, because today we are going to have also a role play. The first half of our session will be this voice, and after that half session will be your chance to act as mediators, as parties, and as lawyers of the parties. So, of course, anytime you want to ask me something, either now or later, I will be always at your disposal. And I think that this opportunity for me to collaborate with you in the future will be very great, because I really think that what we do, what the best thing that we have to share is collaboration. Globality is, the fact. We don't live alone. We have other nations besides us, so we really have to collaborate ourselves, to collaborate between us, and to have all this shared knowledge, shared experience in disposal of you anytime you need it. So please don't be stressed or don't be negative to contact with me afterwards, and I will be always there for you anytime you need me. So let's start from the beginning. I will share my screen. No, not from the beginning. I will. Oh, where is my? Oh, why is that? Why I cannot share my screen?
Olga, can you click the share screen button?
Yes, I can click that, but I cannot see my my slides there. I can see all the other stuff I have open. Let's just close all the other files in order to. See, yes, I know now. That's why I couldn't.
No worries.
Okay, now I think that I will be able to share my screen. Yes, of course. Well, can you see my?
Yes, very perfect.
Thank you very much. Thank you very much. So I will start from, my surname is Tsiptse. It's very, very difficult to pronounce my family name in Greece. So I think that I caused many problems to Mr. Chang pronouncing my surname. So please call me Olga and everything will be okay, because Tsiptse is a very difficult surname. Thank you very much. So we will start from where we stopped the previous time. We didn't have the time to focus on many things that I wanted to share with you. So before starting with empathy, I will start where we stopped the previous time. So in the previous course, we talked about why is psychology so important during mediation. And I think my opinion is that the psychology of the parties, of the lawyers, and of the mediator itself, himself or herself, is a core value for mediation. And I think that we concluded that mediation distincts from other legal processes as litigation or arbitration or other institutions like negotiation, etc. And we said that between mediation and other legal processes, we face common ground. There are separated parties that have disputes, that have conflicts, that have matters to resolve. We have parties as disputants, and there is an independent third party who plays a key role, a key part in their dispute, in their resolution of dispute, of conflict. But between mediation and let's say arbitration or litigation, we have a very significant difference. Do you remember what is this difference that we face in mediation and that differs from other procedures? Please, can you say this difference? Can you name it? Is
there any colleagues? Yeah, please.
Please, do you remember the difference? Okay.
We got Ai Xinyan, please.
First one, the process of mediation is more flexible, and they don't have a schedule, and it's the process totally depends on the two parties and the mediators. And secondly, the mediator just play the role to facilitate the two parties to get their own settlement, and the mediator cannot dominate the process.
Exactly. That's the difference. And in mediation, the parties are the ones that decide. Though in arbitration and litigation, there are no parties that they decide. The judge or the arbitrator will decide upon a conflict. So this is the great difference between mediation and the other processes. Mediation is so important because the parties alone, themselves, decide upon their needs, their interests, their conflicts. So the decision maker in other processes is a third person. The decision maker in mediation are the parties themselves. And I want to tell you a story about a family case. There were two parents, a mom and a dad, who went to the courts for a divorce. And for the other cases that have to resolve, they wanted to have communication with their children. They wanted to have nutrition and all these things. And the judge looked upon the two parties, the mom and the dad, and he told them, I am a third person. I don't know your child. I don't know the name of your middle child or the age of the oldest child. I don't know your names also. I don't love your children. I don't care about them. You care about your children. You love your children. You know the names, the ages, the nutrition favorites and all these things. But you come to me, who I don't know your children, to resolve your problems. That is the difference between mediation and the other processes. We ask a third party who is ignorant, who is not caring about ourselves, to resolve our disputes that we care the most. So, you can see that we have to put our strength to have a good mediation processes, because mediation is the real sunrise for our life, the real, you know, when some dispute is resolved by us, it's something that a relief. And you see this picture that I have in the screen share, that is my favorite, because after I resolve a dispute with my colleagues, my family mates, my roommates, my whatever, I really feel relief. And that is also emotion, that is also psychology. So if the parties are emotionally aroused by anger, fear, negative feelings in general, these bad feelings will influence their perceptions, and thus their judgment will be influenced also as well. And they will not know the true or the false, the right or the wrong. That's why psychology is so important for mediators. Sorry for that. It's so important for mediators to search upon psychology of the parties and the psychology of mediator, him or herself, because it is also important to be in a great balance, in inner balance. Mediator have to be very well educated, very well skilled, very well prepared about the problem that he or she has to resolve. He doesn't resolve. He just mediates. He's in the middle. He listens. He hears upon the parties. So, do you have minimum agreements in mediation? What means minimum agreements in mediation? That means that parties shall agree to mediate. This is a minimum agreement. If parties don't agree to mediate, we can do nothing. The case is not mature. We can go no further. We can close the file and we will say, okay, you're not ready to mediate. Please go to the courtroom and resolve your problems. Wait a minute. Sorry, I have a message here, but I cannot see. Mr. Chang, can you please read the message in the chat? Is it a question or not? Not really?
I think that is a private message.
Okay, sorry.
Because I cannot see it.
I will see it later. We have this minimum agreement. That means that parties shall agree to mediate. If they don't agree to mediate, we can do nothing. And what means the parties agree to mediate? The parties agree to sit in a table. I agree to sit in a table with my disputant, okay, to discuss with them, to discuss with him or she, to try to find solutions that cover my ultimate interest. That means I agree to mediate. Agree to mediate doesn't mean that I will have my selfishness all the time. I will do nothing to compromise, or I will do nothing to put a step behind and to try to find a solution. That is not agreement to mediate. So if parties don't agree to mediate, we can, as mediators, we can do nothing. We have this moral this moral choice to close the file and ask the parties to go and find a solution with other methods, arbitration, litigation, but not through mediation, because we need this minimum standard, this minimum agreement. So if parties agree to mediate, the first step is accomplished. We agree that we disagree and that we came here to try to find a solution. It's not sure that we will find this solution, or it's not sure that we will find a solution for the whole problem. Maybe we can resolve a part of our problem, but it's very important to agree, to sit in a table and to discuss. And discuss means to hear, understand, feel, and of course, to express ourselves, okay? So, to summarize what we have discussed in the previous course, mediators have the beauty to understand the aspects of conflict. When we mediators read a case, study a case, they have to understand all the aspects of a conflict, to understand the diversity of the problem-solving approaches, the diversity in communication and negotiation styles, the ways of individuals are making compromises, because if you are a mediator in international level, international mediation, that means that you will face many diversity. So you have to feel, to understand all these things, to understand the physical space, the venue, the time, to understand the online time and space. You have to understand the attitudes towards us as mediators. You have to understand the specific cultural context of a dispute, whether it stems from a family, community, workplace, industrial, or other commercial, or if there is any other context. Of course, you know, the issue of time is very important, because if parties are tired, or if parties are hungry, or if parties don't have this level of capacity to start discussing things, we have also to understand that it's time to give a break, to have a break, and to have our parties to rest them, in order to have more time to be, you know, to have something better in the future. So when I refer to the word diversities, because as I told you, in international mediation, diversities is a very common thing. You know, maybe it's a couple, a married couple from India and Europe. Other things are in common in India, other things are common in Europe, or Greece, or in China, or in the USA. You have to acknowledge of all these diversities, and that means any kind of diversities, different culture, different religious, sexual orientation, and other. Mediation shall be very well educated, having established certain skills, and the psychology is one of them. A mediator shall be very well prepared for its case, to study a lot, to communicate with the parties before mediation, to call them, to ask them things that the mediators have not understood by that time. So mediators have to be very well prepared before starting mediation, because one wrong thing from mediator, one wrong step from mediator can really break all the story, can really have a very bad influence to the story, to the dispute. So Mediators shall play a very huge role as psychologists, even if they are not. You know, I'm a lawyer, but when I sit and I talk with the parties prior to the mediation, I want to understand what they feel, what they see, all these that are beneath the iceberg, not only what they tell me or what the lawyers want to tell me. I want to understand the way of thinking, the mindset, the way that they look upon a picture. You know, if I sit here from where I am, I can see this number, which is 6. If the opposite of me is sitting right next to me, right opposite to me, which number is he or she going to see? I see 6. The opposite of me, which number is going to see? Anyone? Anyone? Mr. Chang, please tell me the number. I see 6. What do you see?
Sorry, could you repeat the question?
Yes. If I sit here from where I am, I can see the number 6. You are opposite to me. Which number is the one that you see?
9?
Yes, exactly. But it is the same number. It is the same number. I see 6 and you see 9, but it's the same number. You see the position from where you are standing is very critical to have the perception. Your perception is the space, the position from where you are looking a problem. So when I see 6, you are seeing 9 because you are opposite to me, but the number is the same. The case is the same, but I have a different perspective, different view. That's why I have to know, sorry, I have to know what, as a mediator, okay, I have to know what the parties are seeing, because I don't want them to think as I think. I want to know what they are thinking, what they are seeing. So for all these things, I really think that the preparation, the preparation stage of a mediation, when a mediator study the case, when the mediator is being prepared, when the mediator communicates with the parties and the lawyers to understand the perspectives, this stage is the major significant stage for the case to be to be in a good position and to try to find a solution. And every case is unique, you know. The personalities are unique, so we have not to underestimate anything. We have to focus on anything that we have to value any information that we get from the parties and the lawyers. So we have talked about personalities in conflict. Let's go back, so where we stopped the previous time. We talked about these personalities in conflict, and we trying to resolve disputes. We actually try to find interests, either our own interests, but also the interest of the other. And now you will ask me, and you will have this great observation. Okay, I am in dispute with the other. I don't want to hear him or hear her. I want to see him, or I don't want to see her. And why should I care about his or her interest? I'm so angry with him or her. Why should I know? Why should I take care upon his or her interest? Yes, you have to seek for his and her interest, because if you find out his or her interest, you will surely find your own interest too. So this is empathy, and we will talk about empathy in a few minutes. So we have to find that is the interest of the others as well as ourselves, and as ours, because that might end our problem, our dispute, if we find the interest of the others. And I will give you an example. You know, what we say, all mediators say as an example, is the orange example. Do you know about that example? Is anyone who knows the orange example? The orange, the fruit. Come on. Raise hands.
Is there anyone who would like to give some ideas about it?
First of all, can you hear me? Do you understand me? Do you understand me or not? No? Do you understand?
We can hear you clearly.
Very good. So please, please tell me, can anyone, is anyone aware of the orange example? If no, I will tell, but I will be more annoying for your ears with this voice.
Yeah, have anyone heard of it? It's about like saying the inside or outside, but anyone can explain it. Perhaps maybe, I don't know. Anyone would like to speak?
Okay, Mr. Chang, please tell the example with the orange.
I think it's a very simple example. Some people want the inside of the oranges. Some people want the outside of the oranges.
Let's
so
go
if you
let's go from the beginning. There are two persons that they are disputes. They are disputants. Both of them want the orange. They just scream and yell to each other and offense each other. No, it's my orange, or no, it's your orange. No, I want that, you idiot, maybe some characterizations and all these things. What is the real interest of each of the party? Both of them, they want this orange, the same orange, but they don't hear the other. They don't know why the other wants the same orange. Mr. Chang, please tell us.
Yeah, so when you identify the best interest of each party, so you know someone wants the juice to use as make the juice, then they need the inside. Someone needs to like say put into the water and drink that water, so they need the skin of the oranges. So that's you know, it's to identify the issues that they're looking for actually.
Exactly. That is what I told you before, that if you try to find the interest of the other party, that might resolve is the resolution of your problem. Because if I argue with the one that the opposite of me, that my disputant, I argue for the same orange, but I want the peel, the orange peel, and the other wants the juice. I want to make a sweet, orange sweet, and the other wants to make a juice, an orange juice. We don't have the same kind of interest. So if I knew from the beginning that he would like the inside of the orange and I want the outside of the orange, this dispute, this problem would never be arisen. This problem will never be a fact. So if I would care about the interest of the other, of my disputant, and if I knew what he or she wanted, maybe that kind of dispute never would arise. So that's why we really need to know the interest of the others. So let's go again to our slides and to see the types of personalities in a conflict. Let's categorize the individuals into 5 types regarding, of course, these slides, this presentation will be shared, and you can have this these notes. So if you don't want to have any notice, please don't do that, because you will have this presentation. So the 5 types the 5 personalities in conflict are those that are written here. We can see the forcer. The forcer is the one who is who has highly perception of his or her own interest, but not of the others. This is the enforcer. The avoider is the one who has low perception of his, her own interest, and also low of the others. The indulger, the one who has high perception of the other's interest, but not of his own or her own interest. The compromiser, who is in the middle of his or her own interest, and also the other's interests. And the cooperative, who has high perception of his, her own interest, and also low of the others. So we have these 5 types of personalities in a conflict. Let's have an exercise, and please, I want you to participate, because it's crucial for you to participate. It's your time today, it's not mine. Do you remember the acronym OCEAN that comes from the words openness, conscientiousness, extraversion, agreeableness, and nepotism? Do you remember that? Do you remember that acronym? This one? Yes, I think. So let's have an exercise. Who can tell us how these personality types that I spoke to you can mix with these conflict types? I mean, who can be enforcer, who can be avoider, who can be indulger, who can be compromiser, and who can be cooperative? The one, let's start. The one who is openness can be compromiser and cooperative. Is that right? Is that right?
Maybe we can ask some colleagues who perhaps Mr. Cong, would you like to give us some your answer? Or who would like? Is there anyone like Mr. Lu Jinglan or Mr. Zhao Junxi? Would you like to give a try?
You're not being evaluated. You're not being graded for that. So please try. Think. I want to see how you are thinking, how you are seeing things. Yes, please.
Okay.
Yes. Mrs.
Please, Miss Jiang, please.
Well, yeah, the agreeableness, this kind of personality is related to cooperative, and the neutralism, to some degree, the indulger, right? And the conscientiousness, nothing to do with it. And the openness personality is tend to be compromiser. For the extroversion person, it is always an enforcer.
Very good, very good, very good. Yes, conscientiousness is not related to any of these types. Openness is compromiser, cooperative. Extroversion is enforcer and cooperative. Agreeableness is compromiser, and neurotism is enforcer and avoider. Yes, you have to think about all these things. So what do you really need to know about the parties? A mediator shall be very well prepared, as I have stressed this, I have told this many times today. But it's very important to be aware about everything regarding the parties, everything, every single detail. What they really need to know, they really need to know about the parties' the triggers for anxiety and danger, why they are anxious, why they are angry, their current coping abilities, their level of self-awareness and emotional intelligence, their history of trauma, family violence, especially the family cases are really, we have to have a slight idea about all these things. Mental health, of course, we cannot discuss with cases that are serious, that have serious mental health problems. So if parties deal with some such issues, we really cannot go further. The level of physical pain, you know, if I have a car crash and I have a mediation about such a case, a car crash case with some damages, not a serious problem with health, not serious injuries. I wanted to hear about the physical pain. Maybe the driver or the co-driver has been injured slightly. I want to know about this pain. I want to know about their stage of change, their beliefs about what they can achieve. You know, we have to ask them, what do you want to achieve mediating? What do you want to go? Where do you want to go? What do you want to, what are your limits? Because if we have, if we face a person who doesn't want to compromise, doesn't want to have a step back, then really we can do not many things. So is there any technique to overcome the above mentioned changes and that occur and lead us to a spiral conflict? Do you remember that word, spiral conflict? How a conflict goes bigger and bigger? Can we really have any technique as a mediator to overcome all of these things that we have discussed up to date? Of course, there is a trick. There are tips. There are techniques, and that's why you are being trained you're being trained just to access to certain tips, to certain skills that will help you. I will send as readable some materials how you can overcome dead-end situations. And of course, I have already uploaded some things that are useful for you. So please read them in order to be aware and to improve your skills about restoring relations. Some tips that I can give you today are these. If a mediator asks questions, that's a very great tip, very great skill. Questions that can lead us as mediators to reach the perception of the other, to have empathy of the other. The majority of conflicts starts because of a misunderstanding. I didn't know you meant that. I didn't know you wanted only the juice of the orange. I didn't know that you was thinking about that. I misunderstood you. So some things, the majority of the conflicts, basically the family cases or the workplace cases are starting because of misunderstanding. Something that one has said or done and the other interpreted it not very good, not right, because he was thinking something else, or she was seeing something else. You know, we don't see, feel, and hear the same things. I can hear the same sentence as you, but I can understand it very differently because I'm very stressed today, or because my voice is very bad today, and I'm very anxious about my presentation. Maybe I cannot understand what you are going to tell me today. So please tell me again, rephrase that, tell it in another way in order to understand what you are trying to tell me. So with questions, we can reach the perspective of the others to understand better. Tell me again, please tell me again. What are you meaning by that? Tell me, can you elaborate more? What is your interest? What do you want to success with that? All these things. What is, was it what you are thinking about? So the first thing that the mediator has to do is to ask questions, many questions, only questions. The second thing is the active listening. Of course, if you ask questions and you don't hear what the other can say, it's useless. So, okay, ask questions, but please active listen to the parties and to what they are going to tell you, and to the lawyers, and what they are trying to guide, to direct their parties. So how can we start resolving disputes if we cannot be able to listen to the others? And the reason that he or she was urged to act like that, if we are stick to our own perception, if I have this perception, this opinion that can be changed, and I cannot see what you can see, how can we resolve our dispute? We can't. So we have to know the reason of the conflict. We always have to give time to as mediators. We have to give time for the first common session, because later on we will have a role play with mediators. Please, mediators, ask the parties in a common session to express themselves, because it will be the first time that the one party will actively listen to the other party. So you have to give time in the first common session to the parties to express themselves, and to the other party to understand, to listen very carefully and actively the other party. So as mediators, we have to take advantage of any tool that we have in our tool case. And the first common session, that both parties are sitting in a table for the first time after a long time, and they are listening one to another, and they are see the one person, the eyes of the other person. It's very significant for us to understand everything. Give time to the first common session. Of course, the third tip for a mediator to overcome the difficulties of a dispute and to restore relations is to put one party to the shoes of the other. This is called empathy, as I have told you. This exercise needs very good knowledge of the thinking of the other. How can we think and feel like not like ourselves, but like the others, if we don't know how they are seeing things, how they are feeling, how is their perception, what is their opinion about the case? Okay, so we have to find out our own interests and needs, and separate the positions. So these are the tips and some other preparation for mediations, some tips for mediators. These are some sample questions. You can use them. They are very, very helpful. I'm sorry. When do you think about mediation, what makes you feel? It makes you feel anxious, angry, sad, hurt? What do you do currently to cope with anxiety and all these feelings, sadness, stress, anger? What personality strengths do you bring to the mediation that will help you? What are your vulnerabilities? Of course, these questions are not going to be set like that. Of course, you will amend these questions. You will adjust them to the case that you are dealing with. Okay. So, how aware are you of your emotions and the emotions of the others? Okay, here they are going to say, I want only myself, my interest. I don't care about the others. Then we can do magic if you hear this sentence. Have you experienced trauma or emotional shock that still creates distress for you? Are you experiencing physical pain that becomes incapacitating? Okay, these are some tips, and of course, we can have some more questions here. If your heart could speak to you, what would it say to you? If your child's heart could speak to you, what would it say? If your intuition could speak to you, what would it say? If your feelings, emotions could speak to you, if your brain could speak to you, if your fears could speak to you, what would they say? And of course, if you resolve this dispute, how would you feel? What is the next day after resolving your problem? After resolving your dispute, are you going to go home and tell anybody? Are you going to go home and feel happy? Are you going to sleep the night? Okay, these are some things that as a mediator you can use, and they are very, very helpful. Here's some also some things that you can read. Well, preparing, I think my voice is getting better, is that right? Well, preparing for mediation, you have prioritized everything that is important to your clients. As a mediator, I'm speaking, okay? This may include non-legal priorities. Don't concentrate only on just numbers, okay? Remain curious about what is most important to your client, but also what is most important for the other side. You know, you have to be neutral to both sides, either the one that came to you and asked you to mediate or to the other party. You have to be neutral. You have to be caring for both parties. We don't care about what you are thinking about the case. It's not the business. It's not your business to think about the case, whether it's right or wrong, whether party one or party two, party B or party A is right or wrong. We don't care. We just hear the others. We are here as mediators just to hear the others. So you have to make the parties to feel safe in the mediation process, safe with all these things that they are going to hear from you. And let's go now to our today's session, that is empathy. You know, empathy is something that I really like the most about mediation, and is the something that I had it before being trained as a mediator. I was really thinking about the others, but I hadn't realized that, because I didn't know that it was called empathy, though it's a Greek word. It's a really Greek word, but I really didn't know that I was caring about the others. Empathy is the reason that I am so in love with mediation, because I realized the power and the real meaning of the emotions, and not my emotions, the emotions of the others. So that magic moment that came into my life when I started training as a mediator, almost 10 years ago. And I want to give you an example that I had with my sister. I think my sister is here today in the audience. And we now that it's Christmas time, I went with my sister to a cafe, a bar yesterday, just to have a brunch after a difficult court. Because courts are always difficult, mediations are not, never. Mediations are miracles. I sat with my sister to a restaurant for my brunch. I had only 45 minutes to do that. So I wanted very, very in a hurry to eat my brunch, to drink my juice, and to go to the office, to return to the office. And you know, that bar restaurant is brand new in my city here in Thessaloniki. It's a restoration of a very, very good place here in Greece that is called Modiano. And that cafe bar restaurant is in the first floor. And you can see downstairs all the people that are coming and go, and they are buying things, buying goods, buying nutritions, all these things. And I was seeing them, and I thought, if if my knife or if my spoon slips and goes over the head of the persons, of the people that are beneath me, that will cause a really big problem. And that is empathy. This is empathy. This is the way that I look to the others, and I'm trying to be in their shoes, to be in their position, to feel as they would feel. And I asked for the person who was responsible for the safety of the clients in that bar restaurant, and I told him, please do me a favor. The cafe bar is really excellent. I like that, but I want you to put something to protect the people that beneath us, because if I throw something, they will be injured or maybe very bad injured. So please do that for me. And he told me, thank you. And that's empathy. So empathy is the capacity to understand, to feel what another person is experienced. And this is the first part of empathy, the understanding. And the second part of empathy is the capacity to place oneself in another positions, another shoes. That means to respond. So not only understanding, but also to respond, to feel like him or her. So you have to distinct empathy from other terms, other feelings, that is compassion and sympathy. It's not the same. And if you allow me, I will now show you, wait a minute, to show you a video that can give you this distinction. Sorry for that. Where is that video? I cannot see. Mr. Zhang.
No worry, take your time. Or you send me the link. I will share it. Is that in the?
It's not the link. Wait a minute, please. I think.
No worries. Take your time.
I found it. Well,
sympathy, empathy.
Can you see that? Can you see that?
Yes, very clear.
Thank you very much.
In this lesson, I will go through the difference between these two words. Sympathy. Sympathy is a noun, and it means to acknowledge that someone else is distressed due to a certain situation or event. Usually, we can sympathize with someone by showing a feeling of sorrow and trying to comfort the person with our words. This is because we feel bad for them. For example, if your friend's pet died, then you may say, "I'm sorry for your loss." So you're just trying to comfort your friend with words. Empathy. Empathy is a noun, and it refers to actually understanding exactly how the other person feels. This may be because you care for them deeply, or because you understand the exact situation. Maybe you've experienced it in the past. So essentially, you're willing to put yourself in the other person's shoes and are willing to experience their feelings. Again, in the situation of your friend's pet dying, a person who is empathetic usually share their emotions. So you want to help your friend relieve their suffering. For example, you may show emotions such as crying, physical comfort, or spend a lot of time with that person in order to help understand their situation.
So this is the difference, okay? I hope that you have understood this difference because it's very, very significant. So mediation is a very anthropocentric procedure, and mediators shall pay huge attention to human beings, their feelings, their positions, their everything, their position, meaning not the position, their claims, but their where they are standing. So let's start again sharing the other. Where is that? Sorry. Can you feel my anxiety now? Yes. Okay. Here it is.
We have empathy with you.
Yes. Thank you very much. So this you can really Jesus. Why is that? Yes, here we are. Okay, so compassion and sympathy are terms that are associated with empathy, but they are not the same. So be careful, because empathy is in the eye of the beholder. Not only the beauty is also in the eye of the beholder, but empathy is in the eye of the beholder. So ultimately, the parties judge the mediator, and they know whether the mediator seems understanding and genuinely interested in their dispute, because mediators, of course, they say that they show empathy to the parties, but the parties need to know that the mediator has a respectful understanding of their thoughts and their feelings. They need to know that. If a mediator cannot share these things with them, parties may stop the procedure and may don't want to continue any longer. I have been in that situation. I was in a mediation, not as mediator, as a lawyer of a party who was not feeling that she was really getting all this emotion from mediator, and it was almost the end of the mediation, and the whole case would be really a loss. Would be a loss. I tried very, very, very hard restore the damage that a mediator had done because of lack of empathy. And that is very important. And that is also the skills of lawyers, that the lawyers also have to be very well educated about the process of mediation, because mediation is totally different from litigation, and lawyers have to focus on the skills that they have, they shall occur in order to save a case if something goes wrong. So imagine that parties need, I write as parties need a mother to a baby empathy for them, you know, especially when we don't have commercial disputes, but we have family cases or workplace disputes. You know, I had a case that a party was very upset because he was criticized about something that he had done. And he wanted he had claims against the other party. You know, what was the problem? Why he was so irritated and so angry? Because the characterizations that he heard, he thought that it was a critics for his job, but in the end, we decided that this characterization was not personally for that client, that person. It was not for him. It was as a general idea to start working better, but not a critical situation, not a criticism against that employee. So when the other party just asked sorry from the other, the one who was very angry, very irritated, started feeling much better, and the case was really resolved, because the whole point was that he felt very irritated and very angry by the characterization that he had heard. So the sorry word was really a relief for him. So we saved that case just with a sorry, and of course some other settlements that were minus, not so great. The point was that he wanted to hear a sorry. And not just a sorry, which was very big sorry, but really it was that problem. So the solution for us as mediators is preparation and knowledge of the case. Well, how can, yes, this is the spectrum of empathy. You can see we have several terms here: pity, sympathy, empathy, compassion. And you know, you can see that the size of the circles are getting bigger and bigger, because that indicates the ability to positively impact the others. We start from pity, so we can say, I am sorry for you, you know, I heard that you lost your job. Okay, I'm sorry for you. Then we have sympathy. I feel for you. Oh, I have heard that you lost your pet. I feel for you. Then we have this empathy thing that is both, you know, understanding and response. So in empathy, we might cry together with the party. I feel with you. I am really sad about what you are feeling, what you are facing. I was there. I was also there. I know your feelings. I feel with you. And compassion, that was I'm moved by you. You know, recently we have a very, very bad situation here in Greece when a young lady, a student, was had a pedestrian. She was pedestrian, and she was car crashed. She was killed, and I don't know that lady. I don't know that lady who was killed. I don't know her parents. I don't know anyone. But I was really, I was moved by all this situation. I was very in compassion with this family. So these are different, and we have to realize as mediators and to have these skills. So attributes of a mediator. A mediator has to have big ears for listening, clear eyes for seeing, small mouth for focusing on listening rather than talking, big heart for empathy and compassion, and of course we cannot have ego, and big feet firmly on the ground. And finally, summarizing, a good mediator needs to have a good opening statement, how to be addressed. We have to set all the rules, all the things in this opening statement. I have sent you some openings, some tips that you have to bear always in mind. Mediator has to check upon authority to settle whether the parties are authorized or if they have this authority to settle the dispute. Maybe for some companies they send some authorized person. We have to check this authority. We have to check as mediators. We have to check if mediation agreement has been submitted by the parties and the lawyers. Of course, it's a voluntary institution and the process, and that means that whenever parties want to go, they are free to go. They have no consequence upon that. It's not binding process until all members, all parties will sign the settlement, the mediation settlement. Mediators are well educated, prepared without prejudice, with good faith, only for guide and clarify the things that they have to clarify, not to judge or make a decision. We are here to challenge the parties, because sometimes we have to play the role of devil's advocate. We have to ask even difficult questions: how, why, where, when, what, who. We have to keep control of our emotions, because we are humans and can be influenced by the others, but we have to be really focused on keeping control of our emotions and the emotions of the parties. We cannot access anyone to lose control. Of course, mediation is a totally confidential procedure. No one can be testify in court, or can be, mediator cannot be used as in courts if mediation is not succeeded. And mediators have also to do this SMART test. SMART is the acronym from the words specific, measurable, achievable, relevant and realistic, and time-bounded proposal. We have to test all these things. If we reach to a proposal either from one party or from the other, we have to test all these things. Is it the proposal that one party or the other proposes, is it specific? Is it measurable? Is it achievable? Can we do that? Measurable, he proposed to give $1 million. Is it okay, or is it something that he cannot handle because he has no money? Is it realistic? Is it time-bounded? So we have to test all these things. And I think that by that, I have concluded my session, and I think that before letting you to have a break and to be prepared about the role play that I have sent you, I want to ask if there is any question. Is it any questions?
Is there any comments or questions? Maybe your experience would like to share. Would you like to share any experience? Is there any colleagues wish to hand?
Have you understood everything or not? Have you listening to me?
Maybe Mr. Hu Jian would like to give some ideas. What do you think about this? And is there perhaps or any colleagues wish to share some experience? We got Pei and So, please.
Hello. I don't know how to pronounce your name.
Olga.
I pronounce
It's
your
Olga.
name is Olga.
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 Yes.
Okay. Thank you, Olga. Thank you for your very interesting presentation. We have learned more about the mediations, but from now, I feel as a mediator, just like a question and answer machine, Q&A machine, because you see, we should be a listener, and I feel listener is just like a follower, because we cannot actively do anything or deal with the problems. We just can help them to reach an agreement or facilitate their problems to be settled. So actually, of course, the mediator is a good people. You give me very clear opinion about empathy, sympathy, and the competence. So I feel, so in my opinion, I think as a mediator, is a good listener, but it's not good for things to deal with. Are you agree with me? Because
Can you please
hello?
elaborate, because I really
My question is,
yes.
my question is clear. Let me try again. I want to see, as a mediator, we are very good educated. We have more skilled, but we can't passively to deal with problems. We just can help them to reach agreement. In other words, just listening. So I have I'm confused. I'm confused. The mediator, how the mediator facilitate these parties to reach their agreement, because they just can listening and ask a question and answer questions. They can't do a lot of things. So do you agree with me?
Yes, of course, I agree with you, but you don't have to be confused, because mediation is something that is not very easy as procedure. Of course, you have to be trained more and more again and again, and you have to be experienced. So these skills, this capacity, this knowledge, these solutions that you need will come very, very physical, very natural when you are going to be experienced. So you have to watch mediations. You have to attend to mediations. You have to play role plays. You have to ask from other mediators. You have to ask some mediators to let you attend as an observer, because you can't do that. It's illegal to attend as an observer. To many, and that is something that I would like to propose to SCLA, because it's an association that cares about professionals from all over the world. They could organize some this kind of attendances. Anyone who is mediator and has international mediations in English, they could offer you a place to observe, to attend, in order to see how all this procedure escalates, because it's a very structured. Of course, when I was being trained as a mediator almost 10 years ago, as I said, I was also very, very confused, and I told myself, no, it's nothing that I could do. I really cannot do that, because I don't think that I can go up all these stairs, you know. It's very structured. I will lose control. I will lose everything. But if you are in the case, if you are prepared, and if your focus is just to hear, not to judge, not to decide, not to think, only to hear, and to take advantage of the details of the others, of the parties, then you will be there automatically without doing anything. You will be there, you will have all this right point, and you will be never confused. When I had my first mediation as a mediator, I was really very problematic, very skeptical about how could I do that? Am I capable of doing that? And then, because of very well prepared, very well studying the case, and very, very well listening to the parties, I reached the point. I reached all came naturally. I had studied a lot. I had attended a lot of mediations as an observer. I was thinking about very good mediators, how they were expressing themselves while being a mediator, and that all came natural to me, and it was really something else, because I knew that I was there, and that came you know, natural, very natural. So you don't have to be confused. You have just not to think as a lawyer, not to think as something as a judge, only to think as how can I offer relief to these persons. They have hidden feelings, hidden thoughts. They have to trust me. They have to believe that I'm neutral, that I will never do something that I will hurt them, and they have to open to me. They have to feel very free to open all these thoughts, all these emotions, all these feelings, and after that, I will be there to listen to them. And if I find something in common between the parties, that's the point. If I hear something from the one party and something from the other party that is in common, then we are
transfer
yes.
Between the parties, transfer something for each other. So
Yes.
maybe my opinion is not right, but I think as a mediator we have many limitations, but we just can be a third good man. Is that right? A third good man between the parties.
Sorry,
We can understand each other. We can understand each other. We can to be a good third man to transfer their information between each other.
And we
And
cannot
as a
do that. No, the procedure is very confidential with two ways. The confidentiality is for the outside world, for the courts, etc. But also confidentiality is between the parties. I cannot transfer things, information from one party to the other if I don't get the license to do that.
the right point.
Yes, because maybe one, I had a family case that the wife told me that she was very jealous about her ex-husband. That's why she is doing all these things. I knew that. I knew that she was just jealous. It was nothing else. But I couldn't transfer this emotion to the husband, because that will really destroy everything. So without telling the husband that information, I tried to make the husband feel how his ex-wife was feeling. I was asking, have you thought about being a very good husband to her? Do you know, how do you evaluate yourself as a husband? Do you think that you offered your wife everything she needed? Do you think that she was very good, very, very well in your marriage? And he was very open, and he told me, okay, yes, maybe you're right, maybe I was not very loyal to her, maybe I start blaming himself, because he just thought how his wife might have felt during their marriage. And that's just only a small, very, very easy example to show it to you how you can transfer information without transferring any information, with questions.
Okay.
To make the parties
Okay.
admit their vulnerabilities. You have to make the parties feel and express their vulnerability and admit their vulnerabilities. And how can they do that? With empathy. If a party feels the other party, he or she will admit all the vulnerabilities that he or she might has. Sorry. So I think that that's the point here.
Okay.
So Maggie
Thank you.
also has
Very
a question.
useful. Very useful.
Yes, of
Yeah,
course.
I think to some extent, Olga has just explained what I'm going to ask. Because my question is actually, I understand that as a mediator, we need to arm ourselves with a different kind of professional skills, like to be a good listener, to stand very firmly on the ground, and to have the compassion and empathy, sympathy you mentioned just before. And you also mentioned that we need to ask questions. So my question, because I am confused, what kind of question can be regarded as a good question? Shall we pay more attention to asking the question about the facts, or shall we pay more attention to the emotion, what the party feel like? So I'm just thinking about as a mediator, what should we ask? But you kind of answered my question in the the last part. I think probably may ask what's your feeling, and can you understand what's the feeling of the other side, and things like that. Is that correct?
Yes, very correct. A very, very, very nice question, because that's really another problem of a young mediator. What questions should I ask in order not to damage the case, not to destroy the relationship that I have as a mediator with the parties? Because it's very important not to destroy the relationship that we have built, the trust and all these things. that the answer for this very good question is that there is no there is no certain answer, because every case, every party is different. So you have to adjust the questions and the procedure upon the parties that you are having in front of you at that very moment. So if you see that a party is very open person, you can start from open-ended questions. How do you feel about that? First of all, to ask about the whole idea, the whole sports, the whole about his or her life, his or her occupation, whatever in general, to understand what he or she likes, what he or she, to start learning his or her personality. And then if he or she is very open person, you can focus more deeply and deeply, you can go further and further. But you have to be sure that that person allows you to do that, because maybe he or she is not ready to do that. So that maybe it takes more sessions, more hours to achieve there. Of course, you have always to remind to that person that you know, everything you are going to tell me is totally confidential, top secret for me. I just want to help you. I'm here to help you. If you don't want me to help you, please end this story. And, it's okay. I don't bother. But if you want to try to find a solution, please help me to help you. So please be open to me, because you have nothing to fear. I'm totally neutral. I don't decide. I don't judge. I don't. Everything you will say, tell me, it's totally confidential, top secret. And please feel free to open and to tell me whatever you are thinking, in order to find out a solution. If you are seeking a solution, if you're not, I'm not here to persuade you to resolve your problem. So you can, you will see the feelings of the others, and you will go further and further. And if someone is very close person, and he or she doesn't let you go further, then it's you need more time. You need more time with that personality, and you need more open-ended questions about the whole story, or the problems that might bother him or her in general, not only because maybe there are beneath that iceberg, there are more things to resolve before reaching that point. That is the case. So have I?
So can I say that as a mediator, we can also ask questions not only in relation to the dispute, but also like can ask question about other things, even like the personal life. Can we ask things about that?
You have
what
to establish.
have you encountered recently?
Sorry for interrupting. Have you concluded?
Oh yeah, I just finished.
Okay.
I just want to take an example, say like, if the person is very closed and reluctant to say anything, can I ask like, what, like, can you share what have you happened, something recently, why you are not willing to talk to me like that? Anything happened in your like job or family? Can I ask things like that? I think it's kind of personal.
Not personalized to you, the whole story, not asking why don't you want to talk to me. It's not not like that, because it's not you the problem as a mediator, I mean. But you can ask everything you wish. You have to establish a relationship with the parties. If you see that a person is very close and is not willing to go further, then you have to remind him or her that, you know, you are here, you lose time and money. Maybe it's a good idea, if you are not willing to go further, we can stop the procedure, or we can stop for now and come again when you are ready. What do you think about that? Is that good for you? Then you will see that the majority of the parties will say, no, I want to go further. Please tell me, what should I do? Because if he or she didn't want to resolve the problem, he or she would never be there. They would never agree to mediate. So if he or she is sitting to that table of mediation, he or she is willing to resolve the dispute. So you know that from the beginning. You know that he or she came to find you. So you are there. You are in your position. You are out of this thing, and you are trying to remind that person that he or she shall be cooperative in order to be his or her problem resolved. It's not your problem. You don't decide. He or she will decide. So having all these things in mind, you go one step behind, and you put that person into the right position, and you remind that you are losing time and money. It's not in your interest of that kind of dealing. You have to be, if you don't want to discuss anymore, let's stop, because you're losing things here. So something like that. And then you will see that that person will be more willing to cooperate. And of course, the lawyers, in Greece, lawyers are mandatory to be in the process. I don't know if you in China have the same level of legislation, but if your lawyers are attending to the courses, to the caucuses, they are very they can be very helpful for you to show the parties that they have to be cooperative with mediator and all these things. And
yes, very helpful. Thank you very much.
Thank you very much. Yes, another question. Mrs. Ging Wei, is that right? Yes.
Yes. Hello.
Hello.
Hello, Olga. Hello. I made a case. I want to you give some advice. An employee told her boss that she was going to study abroad and could no longer work. The boss asked her to stay 2 more months and hand over her work to someone else before she left. After that, the boss started looking for a new employee and have found one within a month. Then the boss asked the former employee to leave, but she said, I just paid the rent. You should compensate me for the loss of my rent. But the boss thought. Then she came up with it at first, and her work is bad. It's impossible to give her compensation. After having discussed this question, the former employee admitted her work was substandard, but insisted on being compensated before leaving. As a mediator, how to make this case? How to make a mediation between the employee and her boss? Could you please give me some advice? That's my question.
Thank you very much. But I think that this kind of plot will be answered after our session. Please, can you send me that email in order to reply to you, because I don't want to lose time from the role plays, the actors, and because there are many things, and I have not understood correctly all the plot. Can you please send me the email in order to study again, and I will directly respond to you, but I need some time now because I want to read again to understand the whole story. Is that okay with you, Mr. Chang? Can I have this question in written?
Yeah, sure, of course. Please, yeah, Mr. Wei, anyway, I would like to connect you with Ms. Olga.
Yes,
Yeah.
please, because I want to read again in order to see if I have understood correctly. Can you give me that, Mrs.?
Sorry, please repeat.
Mr.
啊，
Chang?
就是课后可以通过那个邮件沟通一下，我觉得会更好一些。
Oh,
啊，
okay, okay.
Okay.
好的。
One
Yeah.
more question is written in the chat box. Empathy is practical skill. Before the break, I want to read that to all of you. Empathy is a practical skill in dealing with cases, emotions evolved. However, to what degree it can be applied and useful in the commercial mediation in which engaging entities are supposed to rational. It's a very great comment. Very great comment. Empathy is mostly for family cases, workplace situations, disputes, and all these things that have emotions. But don't underestimate commercial disputes, because there are other things that are very serious, very significant, such as the power, the imbalance of powers between entities, and all these things that they want to succeed. So empathy, we can translate in commercial cases, we can translate empathy into other situations that can be adjusted to that kind of feelings and that kind of terms. So also in commercial mediation, commercial cases, we can use all these skills regarding to empathy, because there are all these power issues, imbalance of power, or strategical issues that can help us. You know, when two entities have been signed a contract to collaborate, a damage of this relationship, and the damage to the rumor that will follow, and the damage of all this reputation is also something that is governed upon empathy. So don't underestimate empathy to commercial cases. It's not so cruel and strict as you imagine. So that's my comment upon that very excellent comment that I received. Now, because I am really anxious, and I'm really looking forward to hear from the mediators and the parties of the role play what they have to say to us. Please have a break for 5 to 10 minutes in order the parties to read the confidential notices, and we will come back again to see how a mediation can be in practice. How can we practice mediation? And I want you all to be very focused on this plot, and I want you to give a feedback what you would do in that case, or what you would change, you would amend, to give a feedback. Is that okay with you? 5 minutes? Yes.
Yeah, sure.
Thank you very much. Because the previous time Mr. Chang shared a video from Greek music, I will also share a video from a Greek music, but this
Awesome.
will be my favorite. Can you hear it? Can you see it?
Yeah, we can see it, huh?
Can you see?
Not.
No,
Yeah, can see it, but not hear it. No.
not here.
Huh?
Okay. Do
Oh,
you?
yeah, we can hear it. We can hear
Okay.
it. We can hear it. Yeah. Yeah.
I hope you like that.
Yes, very nice. Very dynamic music.
It was Hadzirakis, Manos
Yeah.
Hadzirakis.
Ah, how'd you like it? What does it mean?
Sorry, what?
What does the title mean of the
Oh,
music?
the Vals, sorry, the Vals of Lost Dreams.
Oh, wow.
No, sorry, the Vals of Lost Dreams is something that, you know, you have lost your
Oh,
dreams.
in Saloniki Island.
Yes. So,
Oh,
have the parties the confidential information?
yes, I think Simon share it into the group, and feel free to have a look.
Do you think we can start or to wait?
Yeah, sure. At your best convenience, Ms. Olga.
Okay. Okay, let's start. Mr. Chang, can you please help me to split the, okay?
Yeah, so do you want to not to split the groups?
I want the opening statement to be in common for everyone, and then the mediators will decide whether they will have breakout rooms. I would like the two mediators to rename themselves and to put the indication of mediator. And of course, the parties that are the company future, to rename themselves as future party and future lawyer, and the other party to rename themselves as seller party and seller lawyer. You know who you are. Can you start?
Sir, do you want them to okay.
Yes, I want to start with the opening session, of course. How is a mediation initiated? How they are welcome us, how they are setting the rules, how they are introducing themselves, etc.
So we come with the we have like saying two parties. This I got from Simon from there's a list. On the group one, we have from the buyer side, buyer is Miss Wei Ying, and the lawyer is Miss Yang. The counsel is Miss Yang Xiaojie, and the mediator is Ai Xingyan. So, Ms. Olga, do you want them each one to speak, or who would like to? You wish them to speak first?
No, I want them to start to initiate with the introduction, their statement. They can split the statement into two parts. One mediator will have the first part, and the second, the one is the more general, and the second is more specific about this case. And I want them to the introduction statement is the basic statement where parties can establish this trust and this confidence to the mediator. So mediators have to be direct to the parties and to start introducing all these things that they have in mind as a procedure, because that is their role, to control the procedure. And I want them to be very very focused on how the parties are going to feel after this introduction. So please.
Okay, shall we begin directly?
Yes, please.
Okay, Mr. Zhang, please.
Okay. So shall we start?
Yes, give your opening statement.
Yes, thank you very much.
Okay, thank you. Hello, both parties. Jiang Jie, Council Party call me Jiang, and this is Ms. Ai Xingyan. We are appointed as a mediator in this case, but today we have Ergen company from Greek, and we also have a future company from Italy. Well, due to the COVID restriction, we do the mediation online. But before the mediation starts, and I want to clarify the principle of this procedure. But first, the whole procedure were confidential. The materials, the documents, and the statements during the mediation are not allowed to use for other purpose. And everything that is discussed here should not leave the table. And after that, mediation are voluntarily. Should any parties decide to terminate the procedure, let me know as soon as possible. So if I become myself clear, should we start? Okay.
By the way, Mr. Sanjay, could you give a brief introduction? Oh, let me do it. I just give a brief introduction to the two parties specifically, and the representative of the buyer is Mr. Wu Ying, and the lawyer is Ms. Yang Xiaojie, and the representative of the future company, of the seller company is Ms. It's Ms. Jeremy, right? Jeremy Law.
Yeah, Jeremy Law.
Jeremy Law, and the lawyer is Ms. Yang Xiaojie, and
No, the
so
lawyer. No, I'm the lawyer of Bergen. I'm the lawyer.
okay, lawyer Maggie, I am Ms. Maggie. So do you have do you both of you have any any disagreement of the two mediators, or do you have any do you both of you accept us to
Yeah,
play the role as mediators?
fine with it.
Yeah.
Okay, carry on, Mr. Zhang. Any questions?
Okay. Well, so maybe so we start with future company.
Okay. Should I introduce my company, the disputes?
Okay, sure.
Mr. Wing, before you start, may I just give a supplement? Yeah. Supplement. Yeah. Do you both of you are volunteering to attend this mediation to resolve your conflict? How about the sinner?
Okay, I would like.
Yeah, and the buyer. Are you volunteering to attend this mediation?
Buyer, me. I'm the representative of the future company. Yes, I would like to make this dispute to mediation.
Yeah. I mean how about the
Seller.
representative of seller? Are you volunteering to attend this mediation?
Yes, this mediation is out of my personal and my personal autonomy. I agree to submit this case into the mediation.
Okay, so okay, so no further question. You can begin, Ms. Wing.
For me?
Yes, you may.
Should I introduce the case, the dispute?